All right. This said he didn't say. All right. And maybe clap his hands.
Okay, so we're getting started now. Hello. Okay. So we have now come to the last day of the first major unit of environmental law, problem number 1. And so we're going to discuss the problem and ways of solving it, the analysis that we would put into it. So first of all, this very class session 2 years ago was when the American Bar Association sent their accreditation team to visit the law school to see how we were doing, assess us and whatnot. And so the chair of the team, who's a prominent senior attorney, so not a law professor, but a practicing lawyer, came and sat in on the environmental law class while we were working on solving this problem, going through possible solutions, and he said it was one of the best law classes he had ever seen, best teaching. So that I was very excited about that, and so forth. And you're like, obviously he doesn't get out much, right? But no, it was good because he was impressed at how good, how well y'all engage in problem solving and thinking through a complex problem and different levels of legal analysis and integrating the legal analysis with the broader problem solving and so forth. So he found it very practical, very useful for real world law practice. So I love that. That year, the students didn't do an outline. So we're actually going to be able to do more today because you've already worked on this. But so that's helpful. But I want to start with just an observation that I read through all the outlines, and many are excellent. Okay, so there are many excellent outlines, and what I've handed out here will sort of guide us through some ways of thinking about some of the solutions. It will help us identify what needs to go into problem solving, but I am not looking for you to necessarily do it this way. In other words, you don't have to have a structure that looks just like this. You're like, oh my gosh, I put this here rather than there. Okay. That's okay. That's, if you put, if you were talking about the ESA in the middle of your NEPA analysis, okay, maybe that's not so right on. But my point here is not that you need to anticipate how I would organize it. The question is, have you put together a well thought through, well organized strategy for addressing the problem that is thorough and complete and that includes the relevant legal analysis. Okay? Not did you make it. So what you're going to find, for example, in mine is there are places where I just put some key points that need further analysis to this, basically sort of as an outline, but some of you put the whole analysis in there, right? You put more detail. That's great. You're just further down the road of actually writing this as prose as opposed to just an outline. Okay, so I don't want you to worry about that kind of stuff. We'll work our way through some things, but there are some things that if your overall amount of analysis is considerably leaner than this, that may actually be a problem, because the challenge here is that it's a big problem with complexity. And so, if you are sort of, for example, focusing on just, 2 or 3 or 4 things, then maybe you're missing some key points. There are some points I noticed in, here and there where there's maybe not as much precision and accuracy. So, for example, with species, under the Endangered Species Act, they're listed, not registered. An EA is an environmental assessment, not an environmental analysis, that kind of thing, right? So in other words, you want to be careful because environmental law is very particular in that way. And that's just how environmental law is. So you want to be sure that you're getting those correct, those points right, and not sort of. Mostly what you don't want to do is just do a bunch of stuff off the top of your head, right? I mean, you have the book, you have the PowerPoints, you have your class notes, right? You have the readings. We have, there's a lot of material that you have at your fingertips that tell you exactly what the relevant law is and how it applies and so forth. And so you want to, just sit down and when you're actually writing your answer, just get to the point, right? That hey, this is to help prepare you for your final paper, which is going to be an analysis of one of the three problems. And you want to sit down with all that and use it, not try to remember just off the top of your head, or not sit there and study for 8 hours and then try to write something as if you were sitting in a classroom and had 3 hours and no notes, right? That's not the point, right? It's not an exam where you're supposed to just be recalling off the top of your head. In practice, you're committing malpractice if you're trying to just recall all this complex environmental law off the top of your head. Every lawyer sits down with the material and puts it into their memos or their briefs or their client letters or whatever, right? Is everybody following? Okay. So I just want to encourage you in that way. Okay. Let me start out to see if there are any initial questions. I don't want people to be somewhere over here. Well, we're all over here, so just make sure you're all together. Okay. All right. So the point of what we're doing in this class is coming up with solutions. But when we talk about solutions, we're really talking about a set of strategies for dealing with an environmental problem, right? And so. So when you're in practice, there will be lots of different kinds of legal work you will do where you will never put together something that's this lengthy, this detailed. But when you have a complex problem of this sort, and what your client needs is a set of strategies, all of which have gone through rigorous legal analysis, that's what we're aiming to do. Okay? So that's the idea, and so let's start with the what's in this outline and talk about what we go into. So first of all, as we talked about from the very early in the semester, you want to define or frame the problem. It's useful to make clear in what role are you writing, who's your client, and so forth. All this when you're actually writing, can be done relatively succinctly, right? You can spend, maybe as many as 3 or 4 sentences on this, or you can just do this in a sentence or two, right? Thinking through how to frame the problem is the harder part, but it doesn't have to be, 6 paragraphs of framing the problem, right? And just think about what does your client need. They need to be oriented towards what the problem is, and so forth. Then what you want is a brief overview of the facts and the context, the political, social, economic context, the ecological or environmental context, and the institutional. What you do not want to do, so again, think practically about what you need. You're actually developing a file, right, for dealing with this problem. And in your file, you have this, right? All the background facts. You do not need to put all of this into your solution, right? Into your document identifying the strategies. What you need, though, is when somebody picks this up, you need enough facts, enough detail, including the broader context in which to frame the solutions and the analysis, right? So you know, you want probably a couple paragraphs, maybe 3 or 4 paragraphs, no more. Okay, right? So you want some of the key highlight features. So here I identified 7 types of things. I would provide more detail with each of these, but I would talk about the prairie grasslands as ecosystem. I talk about the prairie dogs as the 5 species, including their habitats and ranges. I talk about the threats to the grasslands, and the threats to the grasslands can be summarized in a sentence. You can break them up into 3 shorter sentences, but right, I mean, you can kind of just get to the heart of what are the threats. What are the threats to the prairie dogs? Again, they can be boiled down pretty quickly to their essence. You want to talk about the interconnectedness of both. Part of the problem here is that we have laws that protect prairie dogs, we have laws that protect grasslands, but they're kind of fragmented, right? They're sort of treated differently, and what we really have is interconnectedness. A lot of the problems have to do with public values and attitudes, political forces, and social effects of these, so including sort of attitudes towards government regulation and federal environmental law, and also attitudes towards the prairie dogs. There's less negative attitude towards grasslands per se, but there may be some sense that, well, this is private property, and if I want to plow up the grasslands and plant it with a bunch of corn, who's the federal government to stop me from doing so? And then some issues. You want to give some overview to the institutional authority and constraints. So, one is that you've got a little bit of a tension between legal solutions and policy solutions. You've got some problems with multiple agencies with different missions and jurisdiction. And then you've got issues related to federalism, property rights, and limited resources. And so I just listed some, one way of kind of characterizing some of those issues there. That's the part that's in italics. So you get a feel for that. Then part of the problem solving is to identify the issues. Many of the issues are going to come up in the analysis. If you do not have a separate section that gives an overview of the issues, that's okay. But just think about your client, somebody reading this, right? They understand sort of the basic framing of the problem. They understand some of the, what you're trying to do. You're assistant director of U.S. Fish and Wildlife Service. She's trying to identify some solutions. Here's some overview of the facts and context. It'd probably be useful to have a paragraph that just gives a brief overview of some of the key issues that you're going to be addressing as you work your way through the solutions, right? So you've got issues related to legal authorities, requirements, and prohibitions affecting the U.S. Fish and Wildlife Service, the need for collaboration, diverse perspectives, sort of the cultural competence questions, the complexity of problems, interconnected systems, nonlinear dynamics, some of that kind of stuff, and then the roles of politics, public values, and the need to encourage and engage in conservation ethics. So those are some of the things I came up with. You may have come up with some different ones, okay? But the point here is that you're sort of introducing your client to an overview of the issues. Then, the whole point is a set of strategies for solving the problem. So you want to get to pretty quickly the solutions, because this is where the real action is. And so I have listed a series of a whole set of solutions. And what you're going to find is that then, as I went through this, I ended up shrinking this down and putting some of those solutions under a broader category, right? So, so what we're going to see as we kind of get down here is things like F, G, H, I, and so forth all fall within one broad category. Okay, so I just sort of, this here is just sort of a placeholder for y'all to sort of see a list of possible solutions. If I were you, okay, so actually, when you were doing this, how many of you came up with just sort of brainstormed about a set of solutions, you know, and had those as sort of your starting point, and then went and did your analysis? Some people do that, right? Okay, yeah, exactly. I mean, that's the right way to do it. That's the best way to do it. Rather than come up with a solution and then get bogged down into NEPA or the ESA or whatever, and then and then all of a sudden, the brain is fried and you forget what your other three, solutions are there, right? I mean, so exactly. All right, so my first one was enforce the ESA against private property owners with habitat of Utah prairie dog. So we've got Utah prairie dog. It's listed. It's there are private property owners, and so what kind of how will this work? So we talk a little bit about the sources of law, identify what's this about. This is an Endangered Species Act. U.S. Fish and Wildlife Service has regulations. Fish and Wildlife Service has listed the Utah prairie dog and designated critical habitat, and the core purpose of this. Okay, now notice what I did here. So the core purpose is to prevent the extinction of species, subspecies, and populations of wildlife and plants in their native ranges. Okay, remember when we kind of went through the PowerPoint slides and we looked at what the statute says? It has a bunch of high-sounding goals, right? A whole bunch of them, right? And there are things like ecosystems and preserving, the future of the planet and blah, blah, blah. It's a bunch of broad-sounding stuff. But when we actually got down to how the ESA really works, what we discovered is that a lot of that was just very broad language stated by Congress. What the ESA really does is it aims to prevent species from going extinct. So it is actually one of the things that you could say about the ESA is it's more of a triage kind of statute. And then actually the case of the book, Salzman and Thompson book, says exactly that. That it's really, we only take action once a species is already imperiled enough to be at risk of going extinct, right? And so that's the challenge with that. And so that's, and I think that's important in terms of thinking about how effective this solution is. But what does it do? One of the things it does is it has some pretty strong regulatory components. Section 9 is the take prohibition. I'm going to define it, talk about how it's been interpreted to prohibit habitat modification or destruction that actually kills or injures species. That's the Sweet Home case. Talk about what kind of activities would be effective if we were doing this. This would be aiming to prevent the poisoning, the shooting, the land development, any kind of ranching or farming that destroys the prairie dog habitats or harms individual prairie dogs. All right? But nonetheless, there is Section 10A, which provides for incidental take permits. And so property owners, if they meet the 5 requirements, and notice I didn't list them in the outline, but if I were writing this up, I would then actually write that out. What are those 5 requirements to get an incidental take permit? I noted here that it has to be done pursuant to notice and comment. There has to be a habitat conservation plan, and there's 4 specific elements that have to be included there. What are the processes? What are the standards? Okay, right? So I'm just using these in my outline as sort of placeholders for things that I would be writing, right? That I would be taking from the book, the PowerPoints, the notes, etc., and putting into my analysis. And bigger picture, the Section 10A is about authorizing takings of species, actions that take species that are incidental to otherwise lawful activities, so long as you avoid, minimize, and mitigate adverse impacts. That sort of trio: avoid, minimize, mitigate. And there's a substantial focus in Section 10A on mitigation measures and funding for them, right? We saw that over and over again, a lot of discussion about mitigation measures. Is the permittee going to actually do the mitigation measures? Is there adequate funding? That kind of thing. We probably want to talk about the fact that the Fish and Wildlife Service has some enforcement tools. All right? Some administrative, civil, and criminal penalties that they can bring against parties that harm the Utah prairie dog or its habitat without getting the appropriate permits. Nonetheless, okay, our actions here, our enforcement, could be met by lawsuits, by legal challenges that to our enforcement actions or our interpretations of the law. So there's several things that we to look at there: statutory interpretation, judicial review of agency action under the APA, the scope of the Commerce Clause, and property takings under the Takings Clause. So we want to talk about the standards of judicial review, right? So, has the agency failed to perform a non-discretionary duty? Is the agency, us, Fish and Wildlife Service, acted in an arbitrary and capricious way, abused our discretion, or acted otherwise not in accordance with the law? Do we have substantial evidence for our decisions? And are we following the proper statutory standards and congressional intent in the ESA? Right? So you see, so we talked about all this, and there it is, all pulled together and synthesized into sort of the essence of how a court would go about reviewing our decisions, our actions, if there was a legal challenge by private property owners. The big picture, which we keep emphasizing over and over again, is: did our agency consider the relevant factors and evidence and make a well-reasoned and well-supported decision on the record? Okay, and that language appears in a number of cases. We emphasize that a lot. It's a big one. Another one has to do with how much deference in our interpretations of statutes and regulations. That's Chevron, Skidmore, Auer. We need some acknowledgement of that and so forth, that's going to be relevant. Any property owner that challenges our action is going to have to show standing, which has both constitutional and prudential dimensions. And so many of you kind of got into those tests in your outline. That's awesome. That's great. I just kind of kept this as a placeholder here because you would want to put that in your analysis. What do we know about regulated parties who are challenging the agency action? Very often they have standing because they are going to be economically harmed if they have to comply with the agency's regulations, right? Or the agency's decisions, right? So we said that's Bennett versus Spear, which actually was a Endangered Species Act case. So usually the regulated parties have a very easy time establishing standing. It's the environmental groups that sometimes have a harder time. And we want to make some mention of ripeness, exhaustion of administrative remedies. So for example, is the action that the regulated party is complaining of a final agency action, right? Final agency action. We want to make some mention of that. And then finally, think about the effects of this solution on the problem. So let's just think about this for a moment. Rigorously enforcing the ESA against landowners or private parties who, whose actions will affect the Utah prairie dog or its habitat. How effective is that going to be? How effective is that going to be? What do you think?
I think you're going to hit a lot of pushback.
Pushback? Okay, so it's going to generate political opposition, pushback, and we saw lots of examples of that, right? We've seen examples where Congress just exempts certain activities from the Endangered Species Act, or they put a moratorium on new listing because of the political uproar over the enforcement of the Endangered Species Act under the law, right? I mean, so it's basically, people are unhappy, and so Congress pulls back from the implementation of the law, or the scope of the law.
I don't know how easy it'd be to enforce it. I mean, you need a lot of manpower in order to do that for the size of the land that we're talking about.
It's a lot of resources, right? So there's a lot of resources involved, and it applies to what? What's going to be private action, but what? What private action?
A lot of it is like agriculture.
Okay, there's a bunch of agriculture involved. Where? Where?
In the West.
No, even more narrower. In Utah. In Utah, it's the Utah prairie dog, right? Okay, one of the things you want to point out is this is just one species of prairie dog. It's the only one that's listed. Okay, it might do a whole lot of good with respect to the areas that are habitat for the Utah prairie dog, but it does absolutely nothing for the whole range of prairie dog populations in the West that are mostly all non-listed, right? Okay, this is one region and one one species. Okay, so it's not really going to be a major tool for grassland conservation, for example, right? A whole lot of grassland that's not affected by this at all. It does absolutely nothing for the prairie dog species that are not listed, or the other ones, right? So all the other species that are not listed, right? So so yes, we could do this. We could actually end up getting a lot of pushback against ever listing any of the other species. Okay, so then let's turn to those. Next option. Let's list them, right? So one possibility is to list the black-tailed, white-tailed, and Gunnison's prairie dogs as endangered or threatened. And the evidence might support the listing of some of those and not others, right? So we would have to see. But again, what's our source of law? The ESA. So now we want to get into the ESA listing process. How does it work? What does endangered or threatened mean? What are the standards for listing? What are the processes? What's the evidence to be considered? So this is the point where you want to make clear that your agency, your client, has to consider the best commercial and scientific evidence available, or best commercial and scientific data available, the economic impact of designating areas for critical habitat, and use scientific peer review, right? You want to identify what effect listing is going to have. It's going to now mean all federal agencies will be prohibited from any action that would jeopardize the continued existence of that listed species, and all private parties would be prohibited from any or all parties actually, any party, any entity or person would be prohibited from actions that would constitute a take of the species, which is to injure, harm, harass, kill, or etc. Okay, so that's the no-take rule. It would lead to designating critical habitat, and the agency would be expected to come up with a recovery plan. Now, there are lots and lots of examples where critical habitat doesn't get designated or recovery plans don't get adopted. They're then met by lawsuits complaining that the agency has a non-discretionary duty to do that and so forth, and there is some tension between the agency's available resources. So if the agency says, we simply don't have the resources to do this right now, the courts are reluctant to force them to sort of say, well, you got to come up with the resources, but a lot of times what will happen is the courts will say, well, you have a duty to do this, and as soon as any resources become available, you have to make this a priority. But that's sort of the gist. And you want to look at what are the alternatives to listing, right? So the process includes decisions to decide that listing is not warranted, or that it's warranted but precluded, right? That's how the law works. And then also that there are ways to avoid listing altogether, such as candidate conservation agreements and candidate conservation agreements with assurances. Okay? You want to talk about the steps in the process and the deadlines, right? So your client, hopefully they're already aware, but you want to include in your strategies, here's what you got to do when, right? Okay? Again, just copy right out of the materials that you have. Know what they are. There's no mystery about it. The law says, right? The statute says how many days and so on and so forth, but you just want a good, clear guideline that they can follow. And then you want to talk about, well, if you don't list any of the particular species of prairie dog as endangered or threatened, you're likely to be challenged in court. You're likely to be sued by an environmental group. Okay, well then, what are the standards that apply? What are the procedures that apply? You've got APA, you've got standing, you've got ripeness and exhaustion of administrative remedies, and so forth, right? So you've got all those same sorts of things in the general sort of thing. Did you consider the relevant factors and the substantial evidence on the record and make a well-reasoned and well-supported decision, right? And if the other alternative is that if you do not list, if you do list, regulated parties may challenge your listing, right? So property owners, farmers, ranchers, industry groups, resource extraction groups, whatever, may challenge your decision to list. And so again, all those same issues, standing and ripeness and exhaustion and standards of review and APA and so on and so forth, right? All those same sorts of things. So you want to identify that. Okay, what does that do for you? It tells you that when you make this decision, you need to be paying careful attention to the statutory standards, the statutory process, the scientific evidence on the record, and making a well-reasoned and well-supported decision. Okay, these are complex issues, but what the agency has to do is kind of not rocket science, and yet the agency regularly messes these things up. They get sued, and the court smacks them and says that you did it the wrong way. And so what's the remedy? The remedy when the agency did it the wrong way is reverse and remand. Okay? The court does not enter an order saying the black-tailed prairie dog is now hereby listed as an endangered species, right? The court does not make the decision. The court simply says, you know, do it over. Send it back to the agency and do it the right way. So, if you are a good lawyer helping your agency avoid those kinds of decisions, you're in this strategy process, your strategy document that you're creating, you're giving them some guidance about, okay, this is what the law requires. Okay, now, if we list these other species of prairie dogs, how will that help solve the problem? Well, okay, let's start with just how it will help solve the problem. That part of it. How will listing these other species help?
It regulates more grasslands.
Whole lot more grasslands, right? We've got now many more areas of land, many more parts of the grassland region that are now going to be subject to regulation as critical habitat for these species. Okay, and again, all you got to do is look at your handy dandy map here in your problem to see what those ranges are, and you can see that if we get beyond just the Utah prairie dog, we now are covering and protecting more grasslands and more and more species of prairie dog. See here, so handy map, right? And so forth. The Utah prairie dog, it's a little purple thing here, right? So if nothing else, you just look at that, you see, hey, wow, if we could cover these prairie dogs with the protections of the Endangered Species Act, we would be covering more species, but also more ecosystems, or a broader amount of the ecosystems, okay? So that could be a positive step forward, and clearly the prohibitions of the Endangered Species Act are very strong, right? They're very strong regulations of both government and non-governmental action, right? Okay? But the limits to this are what? What are the limits?
Private opposition, they don't want to be regulated, told how they can use their land, and then even if they are regulated, they can get incident take permits, and so.
Good. Okay, so one big one is the political opposition. Okay, lots of different environmental statutes generate political opposition, but as we talked about in a number of different examples, the ESA generates a whole lot of political opposition. It's sort of a lightning rod, in part because it is such a strong regulatory system, and it is regulating not just big chemical companies that are dumping a bunch of toxic stuff into waterways, where we kind of think, oh, that's bad stuff, and that's a pretty limited number of regulated parties. But now we're talking about pretty much almost every landowner in the American West and the Great Plains area is now conceivably, potentially subject to regulation, and so that tends to generate a lot of opposition. Another sort of problem with this is that, actually, what was the second thing you said?
The incident take permits.
Yes, that there are exceptions. Almost all environmental law is this way. There's this strict regulation, and then the regulation says, but if you get a permit to do what we have just told you you can't do, you can do it anyway, right? And so this is the typical approach to environmental law. It's actually, by the way, if you take land use next semester, it's the typical approach to land use regulation in the United States. We issue these prohibitions, but then we say, but you can get a permit to do what we just prohibited you to do. And so you have to follow these standards and so on and so forth. So, on one hand, the mitigation requirements, the requirements to have to get a permit to show that you meet the standards, engage in habitat conservation planning. All those things help to protect the prairie dog and help to protect the grassland habitats, but they also allow you to harm the prairie dog and develop or use or alter the grassland habitats, right? So that's a kind of, it kind of works both ways. Okay, what else? Takes a lot of resources. Somebody mentioned that earlier, so there'll be a bunch of resources required here. Okay. The other big one is this is going to apply to particular species and to actions affecting those particular species. It is not a prairie grassland ecosystem conservation program, right? There are going to be grasslands that are not home to prairie dogs that are still going to be harmed and altered and plowed up and developed and so on and so forth. And there's nothing that really requires any kind of systematic management of grasslands as an ecosystem. Okay, so that's another problem with it. And then finally, once the species is no longer in threat, threatened by extinction, it has to be delisted. Right? So again, it's a kind of a triage regulatory program. It's designed to prevent the species from going extinct. It's not really, hey, can we think about how to manage grasslands under these changing conditions and so forth. Okay? All right. So now let's turn to the next solution. Maybe we could use NEPA. Okay, and by the way, it was in the book, and so I hadn't mentioned it, but we have not mentioned NEPA with the ESA at all because all of that ESA analysis, what you have to do under the ESA, is considered the equivalent of NEPA analysis. Okay? So in other words, if you, for example, have to do a Section 7 consultation and you get a biological opinion, the agency does not have to do a separate EIS. Okay, it's considered the equivalent, right? Because you're doing the same analysis. You have to consider alternatives, including the no action alternative. You have to consider the impacts and so forth, right? So the book made some mention of certain kinds of statutes operate, with the same kind of analysis required that you would have with NEPA. So now we're finally getting around to NEPA, and hey, maybe we could use NEPA to protect grasslands and prairie dogs. Well, how does that work? Isn't NEPA a procedural statute? How would it work? Would it actually do anything? So how does it work?
One of the species is on the BLM land that does a lot of mining and drilling or whatnot, and so that would be an agency action to allow a permit for drilling on that land, and that would require the environmental impact study.
Okay.
And that's where you could work collaboratively with your fish and wildlife expertise to talk about things that are going to be specific to the grasslands and the prairie dogs.
Okay.
Make sure that's being considered in the study.
Okay, good. So one thing is pretty broad, right? So it's the agency's action that are going to have a significant impact on the human environment. So now we're no longer talking about this species. We're no longer limited to species that are endangered, right? We're no longer focused just on habitat. We look at grasslands generally. We look at species that aren't listed. All of those, right? All of those environmental impacts, water quality in the grasslands, etc. Right? So we can look at. We have to look at a broad range of the environment and a broad range of environmental impacts. Okay, good. What else? Well, what does forcing an agency to take a hard look, okay, notice I sort of worked in the legal standard, right? The legal standard is hard look, okay? So forcing the agency to take a hard look at the environmental impacts of their decisions. How could that lead to better environmental decisions? Like, did we study NEPA? All right, so how it could help is, first of all, it could, it forces the agency to actually identify, to study and identify all of those environmental impacts. So now that information is available. We're no longer making decisions blindly without any information. The information is available. Secondly, it's available to the public. So this generates public awareness, public attention. People who want to protect the grasslands, people who want to protect the prairie dogs, now are armed with information, awareness, this process where the agency is looking at this. Third is the agency actually has to consider the impact. Now the agency can make the decision to go ahead and take the action even though there are adverse impacts, but it has to actually go through the process of saying that it's doing that. Okay? And so that means that the agency actually has to think about it, analyze it. And so what we know is that there are times when the agency says, hey, we're going to take a different course of action than we thought we would, because it turns out there are all kinds of bad environmental impacts from what we were planning on doing. Okay, so what the point here is that the procedural nature of NEPA can actually influence substantive decisions by an agency, right? Because of the pressure, because of the transparency and knowledge and awareness and so on and so forth, right? Okay, so that is key. The other thing that happens is if the agency fails to prepare an EIS when it's required to, or prepares an EIS that is inadequate under the legal standards, and they're sort of identified, discussed here, right? Then an environmental group can sue the agency, right, for its failure to follow NEPA, right? To either prepare an EIS when it's required or to prepare an adequate one, right? All right, so, and there's a variety of issues that can come up. The failure to consider the no alternative, the failure to engage in cumulative and analysis of cumulative and synergistic impacts, those kinds of things, okay? So here, why is it that standing is easier for environmental groups to satisfy under NEPA? Anybody remember what it is about NEPA that makes it easier for environmental groups to have standing? What's the harm?
Major?
What's that? What's the harm if the agency doesn't follow NEPA properly? Oh, by the way, we've sort of glossed over the procedural things. If they don't follow the right procedures, that's another thing. So if the agency doesn't follow the NEPA requirements, what's the harm to the environmental group?
I mean, they lose probably their right to conservation, I guess, in the area.
So the environmental group, does it have a right to conservation?
I mean, if there's I figure there's a federal agency, they probably do.
A right to conservation?
Or, I mean, yeah, a right to further their goal as an environmental group, I guess.
Okay, so I'm not sure that that's necessarily going to be found in the statute. I don't know that the statute creates an a right in the environmental group to have their cause further. What does the statute provide? What does NEPA? Yeah.
Would it be harder for them to show their injury?
No, it'd be easier for them to show injury. Okay, so the thing is, NEPA is easier for the environmental group to show injury. Why? What's the injury? Yeah, exactly. They didn't prepare the EIS, or the EIS was inadequate. It's the informational, it's the procedural. This is designed to ensure that this is an open, transparent, informed decision-making process. So the whole idea behind NEPA is any member of the public is harmed when the agency doesn't consider the environmental impacts, or doesn't do a good job of preparing the report so that everybody can know, or doesn't provide the report to the public, that kind of thing. Does everybody see that? Okay, so the procedural or informational harms are broad, and they're sort of broadly contemplated by the statute. So it's much easier to establish standing under NEPA, which means that, of course, environmental groups love it, right? Because it gives them a chance to sue the agency and say, hey, you're making these bad decisions, they're causing environmental harms, which goes back to the idea that the environmental group is advancing its goals, its conservation goals, but rather than saying Congress has expressly protected our conservation goals, or specifically guaranteed our conservation goals. Instead, what they say is Congress has guaranteed that there will be informed decision making, and there will be analysis of the impacts, and this information will be made public, and that kind of thing. All right, so let's turn now to management of federal lands. So here, there are a variety of federal lands that are going to be home to grasslands, and that will be home to prairie dogs. And so there are a variety of statutory and regulatory sources of law that govern different agencies in their management of relevant types of federal lands. So the national grasslands, national forests, national wildlife refuges, national parks, and BLM lands. So two big challenges. Okay, so one great opportunity here is agencies have authority and statutory mandates to manage these lands for ecological purposes. Okay, so that actually sounds pretty helpful. And it's all federal land. We no longer talk about private property owners and so on and so forth. So so that's easier to do. Two big problems. First big problem is what? It's a bunch of different agencies with a bunch of different statutory mandates, a bunch of different statutory standards. So different types of lands, different types of agencies, different types of purposes for which Congress has directed the agencies to manage those lands. Okay, so that creates a lot of fragmentation. It makes it harder to coordinate. It makes it harder to ensure that we will actually get grassland ecosystem conservation out of this. Much easier to get grassland ecosystem conservation on the national grasslands, right? And probably also on the national wildlife refuges. Why? National grasslands are specifically to be preserved as grasslands, right? That's a specific purpose, right? So we have this Bankhead Jones Farm Tenant Act and so forth, gives us some broader statutory standards. The national wildlife refuges, not only are there primarily environmental purposes to be served there, but who controls them? We do, our client. Our client controls the national wildlife refuges, so we can do more there. Much harder to get the U.S. Forest Service on board with managing the national forest, the BLM, managing the BLM lands, and the National Park Service managing national parks, all for grassland conservation. Okay? So that's one challenge. The other challenge is some of the standards emphasize ecological, values and purposes, right? And direct the agency to manage for multiple uses. So some of these involve more extractive kinds or more impactful, adversely impactful. So range, okay, the idea that range, what does that mean? That means grazing, okay? So we've got a bunch of cattle grazing as opposed to protecting the grasslands and protecting the prairie dogs and so forth. Cutting timber and so forth. And then as we know, as a practical reality, as somebody mentioned earlier, we've got, I think as Kirk mentioned that, oil and gas development and mining and other kinds of activities. So on one hand, there's some potential legal authority here. There's some potential opportunity. On the other hand, it's limited in some respects, right? Does everybody see those kinds of issues? And so we kind of want to identify that. Thoughts or questions about that? So, and also, by the way, one other thing I want to talk about here is when the agency engages in management actions, right? The question is, what kind of decisions are they making, and is that subject to judicial review? So if the agency is making a very concrete, specific decision about an action, right? Or making a decision about a concrete, specific action, right? That's judicially reviewable. If they are merely making a plan, right, there are several barriers to judicial review. It might not be considered a final agency action. It's harder to establish standing, those kinds of things, right? Similarly, programmatic decisions, okay, simply deciding to organize a grassland management program is generally not considered a final agency action. It's just generally considered, a more of an organizational thing as opposed to a concrete, specific action. So in some ways, we kind of, maybe as an agency, we like not being sued all the time, and we like being able to say, hey, we can make some plans without environmental groups or regulated parties suing us all the time. But on the other hand, it also means that there's less accountability and less scrutiny. Okay, so let's turn to the next grouping of solutions, which is engaging non-federal stakeholders. And here, in a lot of you, I identified these in different kinds of ways, different kinds of structures, and what we know is this is going to be essential if we really want a systematic approach to grassland and prairie dog conservation, because we have a lot of non-federal actors that are involved. I mean, private property owners, industry and development and ranchers and farmers and so forth, state and local governments, state and local lands, etc. And so there's several different possibilities here. State and local government authority, trying to incentivize and facilitate and encourage private property owner land stewardship, promoting conservation easements, and the use of qualified land trust for conservation purposes, multi-stakeholder collaborative processes, trying to get different stakeholders together. Several of you in this area mentioned specific kinds of stakeholders that you might want to get plugged into this. I think that's great. As part of, if you're developing this strategy, you would want to identify who are we talking about? Who might be involved? So you might identify some specific kinds of stakeholders. Educate and engage the public and conservation goals and sort of connecting to the grasslands as ecosystems. So we talked about special places, the ecology and psychology of place, and also connecting to prairie dogs as keystone species, thinking about them as being really important to these places we hold special, and that sort of thing. So what are we doing here? We're talking about the use of a variety of tools, some legal, some non-legal, to try to bring more participants in the conservation purposes. And so we know from both the history of the ESA and also the Mono Lake case study is that if you take a purely regulatory approach or a purely legal approach and you don't actually engage the public, you don't engage multiple stakeholders, that very often your efforts are limited in their effectiveness, right? And that you aren't getting all the parties involved the way you need to. On the other hand, one of the things that we know about these sort of multi-stakeholder processes is that they can end up resulting in a lot of feel-good generalities and not a lot of very concrete conservation actions that involve trade-offs and sacrifices that are necessary in order to actually get conservation, right? And so, you get a bunch of people together and everybody agrees in principle that, say, grassland conservation is a good thing, but nobody's actually willing to do the things that it takes to actually achieve it. Or, or you don't actually, sort of figure out, okay, who's going to pay for it, or who's going to change their practices, or that kind of thing. So that's a real problem, a real challenge in this area. But again, I think one of the things that's important here is to tie some of this into what we know about the relationship between law, the environment, which is, again, a broad system that doesn't neatly fit all of the sort of jurisdictions and who controls what, and then also what we know about society and the idea that you have to incentivize good behavior, and you have to develop conservation ethics if you want actual conservation to happen. Okay. Next big area is managing grasslands and prairie dogs adaptively for resilience. Now, this could be adaptive management, it could be adaptive governance, it could be adaptive law, it could be adaptive planning, it could be just resilience as a goal. I mean, there's lots of different ways you could tackle this, okay? And again, I want to emphasize there's not one right approach, but given what we've studied in the class and given how important this is and the fact that really every environmental agency is considering this, you need to wrestle with sort of adaptation and resilience. The idea that you can't just sort of mandate up front this sort of linear, okay, now we'll do this, and then this will happen, and this will be the outcome, because the world is much more complex than that. There's a lot of uncertainties, a lot of surprises, a lot of cross-system effects. If nothing else, climate change is always a phenomenon. So what happens if you're managing for grassland conservation and all of a sudden we have unprecedented drought every year and the grasslands are dying? Or what happens if the prairie dogs are susceptible not only to the plague, but now all of a sudden some other disease that has never existed in North America and is now, again, because of worldwide travel, because of climate change, because of other things now, is decimating the prairie dog population. Okay, you as a federal official need to think about, especially as a lawyer, you need to think about, okay, what's our legal authority to adapt to that? What's our legal authority to make changes in how we manage and regulate? Okay, and the part of the problem is that there is some authority, but it's actually not very much. Most of how law is set up is in this very certain, traditional, linear kind of way, right? So think about what we're doing with endangered species. We don't do anything until they're at threat of extinction. And then all of a sudden, whatever you do, don't harm the species or its habitat, right? That's a very sort of rigid approach, and it's a very last minute after the fact kind of approach. NEPA, okay? NEPA assumes that you can predict all the impacts up front when you do your EIS, right? I mean, when are you ever actually going back and revisiting that, okay? We talked about the duty to supplement, but what we found is that generally courts are very deferential to agencies' decision not to supplement their EIS. So NEPA is an example of that kind of upfront, we know everything, we can predict with great accuracy, and we just know that's not true, right? And that's just not true. So part of what this gets at is the need for some solutions that are more adaptive, right? More resilience focused. And so you might think about that. There is, as we talked about in class, some evidence that this is happening more and more in environmental law, that we're actually moving in this direction, that resilience is a goal, and that we have created some mechanisms for more adaptation. We also talked about the idea that sort of the current environment is very anti-regulatory, very sort of pro-resource development, and there's some questions about what kind of impact that's going to have on an agency that's trying to engage in grassland conservation, prairie dog conservation, right? Okay. Now, a couple ways to look at that. One is to say that this kind of the sort of current politics of environmental regulation and environmental law at the federal level is a disturbance that is leading to the collapse of conservation approaches. Okay, so that's one argument. The other argument is that it's a disturbance that's leading to alternative ways to achieve conservation. Okay, remember what some of the reading was talking about state and local government roles, international roles, and private sector roles. It was mostly about addressing climate change, but there's some arguments that while there might be some negative effects of this, that it's also kind of shaking things up and maybe leading to less reliance on federal agencies and more reliance on other parties. Okay, so I just kind of present both sides of that, kind of both out there, and you can kind of run with whatever works for you in that, but just to sort of think about that. Questions about that? Okay, so finally, at the end, right, you're going to need to pull it all together. You need to pull it all together. So you've looked at various solutions. You've looked at the legal rules, the legal standards and procedures that apply to them, and you've gone through your legal analysis. You've looked at your solutions in the context of, sort of the broader context of the problem, the ecological, the political, the social, right? I mean, you sort of looked at, what will these solutions do for us? How likely are we to be able to use them effectively? That kind of stuff, right? Everybody see that? Okay, so that's what we've done so far. So then, in the end, though, your client will be most dissatisfied with the typical law school answer of "it depends," or it could be analyzed multiple ways, right? We teach that to you in law school, right? And it's an important process to not see everything in this, purely black and white, and there's just always one right answer kind of approach, right? So, but on the other hand, if you were a lawyer and you were trying to help your client make some decisions, adopt some solutions, in the end, you also have to make some recommendations, right? You have to actually get to the point where you're saying, hey, this is what you ought to do. So what do you guys think? If you're giving advice to the U.S. Fish and Wildlife Service, you're giving some strategies, what would be your elevator speech? Your five, a couple of minutes up, going up the elevator, talking to the Deputy Secretary of the U.S. Department of Interior, and they're saying, hey, what should we do about grassland conservation and prairie dog conservation? And you would say, what?
I think that regardless of whichever one, the different stakeholders being involved in the process is absolute. There's no way you can get around it without. And I was thinking about it today. I was thinking about how when we went to the bridge and the environmental field study, and David Caron was talking about how they had those public meetings for a year, once a month, and just had people come and give them ideas. And that's too large of a scale probably for something that has a more pressing time scale like this. But I don't see how you can get around it.
Okay, good. Good. So identifying a particular solution that you think is going to be really essential, and why is it essential? Okay, good. What else? Would you have something else that you'd...
I think along with any of the actions you take, just educating the public, the businesses, even the government agencies would be important, because I don't think people will really be motivated to act or to go along with actions unless they know why they should be doing it or what can actually be done to help.
Okay. Okay, so part of that engagement of the public is a substantial education component. Okay, good. What else?
I think too, focusing a lot of that education on the actual private landowners in the area, so that they can maybe change their minds about how the species interacts with their land, which can then help get political pressure, or it won't have as much pushback
Okay.
if politicians decide to.
Right, so dealing with the realities of that political pushback, and then that you have to build some support in the private sector. Okay, good. Okay, does anybody want to sort of say, you can educate and encourage all you want, but when it comes down to it, that oil company wants to drill right where the prairie dogs live, and there's not going to be anything other than federal regulatory power that's going to stop them. Anybody want to take that? What do you? Nobody? Okay. Well, I mean that's at least something you need to consider, right? I mean that it's very optimistic. Right? I presented episode 4 of fourth generation environmental laws and hopeful, optimistic kind of thing. But we also need to deal with the reality that there are stakeholders, parties, people, members of the public who are not going to embrace grassland conservation or prairie dog conservation, regardless of how much education and engagement you do, right? I don't know how many, but there are going to be some, right? There are going to be some that their economic interest is to use the lands and the environment for other purposes. There's going to be some folks who are like, okay, prairie dogs are an annoyance. I mean, you can tell me how important they are to the ecosystem, but my cattle have broken legs. We've got plague running around my property, right? I'm gonna shoot them if I can. I'm gonna poison them if I can, right? And that's very hard to build that. So there's an argument out there that a certain amount of regulatory authority just has to be exercised. Not, right? Justice Holmes, it says, the law is not the good actor model, it's the bad actor model, right? I mean, you have the law because there are people who are never going to do the right thing. Okay? That's the point. Okay, so that's just something to consider. I'm not saying that should be part of your answer, but it's just to think about. Another thing to think about is don't underemphasize the role of standards and procedures in federal management of federal lands, okay? That's a whole lot of grassland, okay? It is fragmented and so forth. You've got multiple use and so forth that's out there, but you've got a fair amount of ability to either control that or to get other agencies on board. Easier to get other agencies on board than to get some grouchy rancher in Utah on board, right? Really, it is. Okay, last thing I just want to emphasize, and then we're done, is that as this particular outline points out, the whole sort of fourth generation idea, that we really just need a multimodal approach, or a toolbox approach. We're going to actually need some of all of this. Maybe we won't need every single one, maybe not all of them will be effective, but there might not be a single solution. The agency might have to do multiple things, and that might be where we are in environmental law these days. Okay. On Wednesday, we turn to problem number 2. So we'll get a chance to dig into that.